time to move to the next category, which is sole representation. Yes. So please, can you explain this category and its...
Of course. I mean, in general, not just for migrants, but there is this term called sole representative for those representing an overseas business in the UK. From immigration point of view, we refer to that category as representative of an overseas business. So this category is a really old category. It has been around for many years, and for obvious reasons, because again, UK would accommodate businesses looking to expand and tap into the UK market. And this is the category that actually allows businesses, overseas businesses, to send their senior employees to set up either a branch or a wholly owned subsidiary in the UK. Even though this category has been around for many years, recently, I would say recently, but it's about 6 months now, so it's in June 2020, last year, we had some changes in the immigration rules regulating this category. I think it would make sense if I may explain also, prior to these changes, some of our audience may know that we used to have a category called Tier 1 Entrepreneur. Now, the Tier 1 Entrepreneur category was for those looking to invest £200,000 in the UK. That category has been closed, and for anyone looking to come to the UK to set up a business, you right now have the investor visa route, which you need to bring 2 million instead of 200,000, or only if your business is innovative enough, and we will discuss that with 50,000 you may set up a business. So this now prevents any traditional businesses setting up in the UK. So the only available category, if the business meets the requirements, is this sole rep and the representative of the overseas business category. And this category has been used by many overseas applicants in the last, I would say, 1.5 years. So it's becoming more and more popular. So the changes in the rules was in a way in response to these an increased number of applications. So the Home Office now are trying to make sure that only those, again, the term genuine and the genuine businesses are allowed to come to the UK. I was expecting the changes. I was expecting it to be even more strict, but in terms of, for example, what qualifies as an overseas business, I was expecting maybe changes like businesses with minimum 50 employees, businesses minimum $1 million or plus turnover, or businesses which has branches in at least 2 different countries. So they didn't do that, but what they did is they introduced the so-called subjective assessment, and I will explain. And also they explained that they will also look into those applying to come to the UK and their family members, and if the family members are related to the business, they restricted who can come as a family member. So this is important to understand, because this was in response, as I said, to control the number of those coming to the UK. Let's focus on the basics of the category. So who can come to the UK under the representative of an overseas business? To start with, if your business has any potential or actual business in the UK, and you want to send your representative, and who can be your representative? Someone who is a senior employee, or someone who does not have major shareholding in the overseas business. So the idea behind this is that the actual business, the head of the operation, remains outside the UK. So if they allow the business owner to come to the UK operation will no longer be a branch or a wholly owned subsidiary. Therefore, they need to make sure that only the minority shareholder or a senior employer comes to the UK to represent the business. So that's one of the requirements. You cannot be a major shareholder to come to the UK to represent the overseas business. I mean, which makes sense, again, because you're sending your representative. You have to have your business owner outside the UK. Then they have this so-called, as I said, genuine assessment. And this is important. You will need to establish that the nature of your business or the industry that you are operating requires you to be in the UK. And this can be established in two ways. Either you already have existing UK clients, or you can show that because of the services you provide, you have potential and that you want to be in the UK to tap into the UK market. And that's how you establish it. It's a genuine business decision. It's similar to the skilled worker. If they feel that you're using this route to secure immigration status for someone, then they would refuse the application. Just very briefly about the dependents, family members. Now, we used to have clients that they run a family business, and the shareholders would be, for example, husband and the wife. And we used to apply for, let's say, the husband, who would have 40% shareholding, and then wife would come as the dependent, and the wife could have maybe 60% shareholding. Now, under the new rules, unfortunately, this won't be possible because the wife having 60% shareholding is seen as the person controlling the business, therefore should not be coming to the UK. So that's also important to look into. I mean, the changes are, again, to me, all make sense, and it's just trying to make sure that those who are genuine and who are looking into expanding their business in the UK can come to the UK. And they did not make changes as I expected, which may be a bit too rigid. So they will be flexible depending on the circumstances of the business. And if they are satisfied that the business needs to be in the UK to expand, the application will be approved. And we almost on a weekly basis have applications from different jurisdictions, not just from Middle East. And this is a popular category, and it is actually successful. So far, we have so many success stories since the change. So the changes are not scary. It's simply that you need to submit your case in detail and explain that you have to be in the UK and that you're sending or appointing the most senior employee or the most suitable person for the purpose of this category.
What is the turnover requirement for this?
That's a good question, but again, the rules are not that rigid. So they're not going to ask that, okay, you have to have 1 million turnover, you have to have 500,000 turnover. And I'm not sure if the question is about for the first application and the turnover of the parent company. So there is no requirement for that. Even for extension application, when you come to the UK and you set up the UK entity, when you apply for an extension, there won't be any requirement of a minimum turnover. There will only be a requirement that you have generated business, because it may be that you need to be working on securing a contract for 2-3 years, and eventually, as long as you secure one contract, doesn't matter what's the value of the contract, and it's a genuine business, you will and you should be able to extend your visa. So there is no minimum turnover requirement.
Most of the people generally ask this question, that is it that their kids can access to the school? Do they need to pay the fee? And the second question in this is that can they access the hospitals for medical care?
Yes, let's start with the children. Just the general policy, and this is also in the rules, that UK authorities must act in the best interest of the children. And this covers the migrants also. So the education, primary education, secondary education before university studies are part of the children's education, and as a result, those who are here as the dependent children of migrant workers, they will able to access to the UK education system free of charge. They don't have to pay. But as I said, this is in line with the general policy of acting in the best interest of children. And this is as extension of that. They would also, of course, be eligible to use the National Health Services. But the rules change about the National Health Services. There was a policy decision. Now every migrant is required to pay a contributions called immigration health surcharge. So it's effectively you're coming here, paying your contribution to use the National Health Services. But after that, there's no limit. I mean, as long as you need treatment, you will be allowed to use NHS, and you don't need to pay every time you use NHS, as long as you pay the immigration health surcharge.
That's great. That's great. So it means that those people who want to come here and want to settle and work, they have no worries in terms of their kids' education because in any case,
Correct.
kids' education will be free. And for
Correct.
healthcare, they will be paying everything in the start of their
From the
visa.
start, correct. A lump
So they
sum
will
payment,
be.
yes,
Hmm.
and then it will be covered.
That's great. That's
Yeah.
amazing. And one more question someone asked is that what is the requirement in terms of the employee transfer? Like if someone is a general manager, how old your employee should be if they
This is
want to
actually
transfer?
interesting. This is interesting. Again, there's no age limit, but I can give an example, practical, just example that would make it obviously easier. We had a case that one of the logistics firms, international logistics firms, wanted to send one of their employees to set up their UK entity. Normally, we would require a list of employees and we provide the salary table. Normally, in general, you would see that the higher the salary is, the more the employee, the seniority level is. So a higher salary implies seniority. But in this case, the business wanted to send someone, not really someone close to the top of the salary table, but someone they really believed in, and she was quite junior, but they believed in her credentials, and she was genuinely the most suitable candidate for the business and the management. Immigration authorities, UK immigration authorities, they picked on that, and they just wanted to question, and that's just done normally part of an interview. And because the candidate was aware of the product and naturally was the most suitable candidate, she was just comfortable with the interview, and after the interview, her application was approved. So again, it's on a case-by-case basis. So the answer is no, there is no age limit. Someone who is 18 may come to represent an overseas business, as long as you can explain why this person is the most suitable person to represent the overseas business and show that he or she has the relevant skills.
That's
Yeah.
an amazing option for
These
the.
are all good questions. I think this way it's more practical. So feel free, any other questions from the audience. I find it's easier this way to explain rather than me going in technical details.
That's good. So I will summarize for the audience that if you are doing a business anywhere and you want to transfer one of your employee who knows the business secrets and you feel that they are really important for your business, so
Yes,
it's likely that you have an option, and this manager will be getting like the life of this manager can change in terms of
correct, correct,
living in the UK and the kids and
correct,
and these folks can also qualify for indefinite leave to remain.
correct. So let's just use your example, Dr. Musa. If you decide that you want to set up a new office here in the UK, and as an extension of one of your business interests, not just in Middle East, and then you want to appoint one of the managers. So the manager that you're appointing to come to the UK to set up your business would have initially 3 years visa, and at the end of that 3 years, you would need to show that you generated business in the UK. Then you would have 2 years visa for an extension, and at the end of the 5th year, your manager would able to apply for settlement and permanent residence, or indefinite leave to remain, you can refer it as, and then they can continue obviously working for you, or they will be free from immigration control. Maybe, I don't know if you had this question from the audience, but they may want to know if there is any minimum salary requirement for your manager in the UK working as your representative. There isn't any minimum salary requirement. Of course, the manager needs to get paid the minimum national wage, but also depending on their personal circumstances. For example, if your manager has family members and they live in central London and they're renting a property in Chelsea, and then they pay maybe £3,500 per month as rent, their expenses will be higher than someone who will be representing a business and based maybe in Cardiff. So it really depends on their personal circumstances. But when you apply for an extension, you will need to show that the salary you're paying your sole representative is sufficient for them to cover their expenses, including their family members. So that's we
That's
come.
a very interesting point, actually, you raised, because if your employee or business is in central London, the cost will be different if
Of
they
course,
are in the maybe in Cardiff, as you said, in Wales.
correct,
That is a bit cheaper area, and it depends
correct.
like where you stationed at. So this is a very
Correct.
valid
I mean,
point.
maybe someone living in Cardiff, 26,000 gross per annum with one child may be easily enough, but it may not be enough in the UK. And that's a problem because that salary needs to be enough to cover the family members' expenses.
That's great. I think uh, how much time it takes. Some people ask that total procedure till you select an employee and you need to process this. How much
To be honest,
time, weeks, months it takes?
preparation, the time for preparation, it really depends on our client. It's like it's a teamwork because we work on these cases together. We build the business plan together because we need input from the business. The business will need to explain their plans, what they've been doing. So we have clients that it would take 2 weeks just for us to prepare the case. We have had clients that it takes 8 months, 10 months for the case to be prepared and for them to be ready to submit. But after the application is submitted, normally it's 2 to 4 weeks, maximum 6 weeks, you get a decision. Normally, I mean,
That's perfectly
it shouldn't take too long
clear.
after the application is submitted. It's about the preparation, and preparation, it depends on the client also. If they're organized
That's
and if
great.
they're
So
ready
if
to.
we get a very well prepared client who has a set of documents, their audited accounts are ready,
Correct,
the banking transactions are good, and
correct,
the employment proofs are very solid. So, and then it
correct.
will be easy for a
We can
solicitor
move
to
pretty
prepare the
quickly, correct. But compare this with a case that the applicant who will be coming to the UK does not have a UK degree. They will need to take the English test. There is an English test at a minimum level, not B1, A1 level. And then we will need to show, like you said, companies' audited accounts, or if they have audited accounts or financial statements. If they're not ready, they will have to get those prepared, translate them, and we will require some other company documents, notary statements, notarized statements. So some companies, because on a day-to-day basis they have other issues that they need to attend to, they delay these. But if they can quickly prepare all these documents, then within 2, 3 weeks, 4 weeks, we should be able to submit the case.
very fast and quick option. I think people should utilize this no matter they are in any part of the world. It's not
Yes,
only they are in Middle East, you are in Africa, you are in India,
there is no
Pakistan,
restriction
Sri
in
Lanka.
terms of correct. There is no
It's a
restriction in
very
terms
good way
of
to bring your staff, expand, contribute to the
correct,
UK economy. Because
correct,
anyone who makes branch here is obviously contributing to their exports and the
correct,
economy in
correct,
UK. So it's a global
correct.
advantage to
There is
expand.
also correct. There is also it's a bit of an academic discussion maybe, but the definition of business. What qualifies as business? So obviously, in simple term, a limited company, limited liability company, these are acceptable, but not necessarily always that you need to be just a limited company. There are sometimes non-for-profit organizations or partnerships, limited liability partnerships, different forms of businesses, and if they need to expand, then they can. I mean, think about a law firm, for example. In some countries, you can't be a company as a law firm, you can only be a partnership. So that law firm may want to set up a branch here in the UK, and that's possible. So it's not just limited to companies. It's other forms of businesses are also acceptable.
That's also very useful information because when you talk about limited liability company, generally we think that a big size company can only transfer by a
Correct,
partnership or a sole trader, but you need to show that you are a real business, you have a banking
correct,
transactions, you have accounts, and you are your employee is working a bit time with you and he knows the trade secrets, and if he
correct,
really goes in UK, he's going to play some active role for your company, and this is going to benefit the UK economy and the country you operates from. I
correct.
think this is a very lovely discussion in terms of
Thank you.
sole representative option,
I mean,
and I
this
am
is
sure that
correct. This is very
no
popular.
one can does better than us, because we have a lot of clients all over the
Yes,
world, and so many years this product
correct.
has been.